I think we're live. We are indeed live. All right, everybody, how is everything going? Mic check. Let me bring down one window and just make sure I see myself in the other. Oh, I don't see myself yet. What's going on? Let me refresh. See myself. Okay, good. Let us just do this. Perfect. Okay, here's an interesting thing, people. We're actually simultaneously live streaming on Rumble. So anybody who's so inclined to go check Rumble, there is no live chat as of yet, but I was just talking to the CEO, and both live chat and a super chat function are coming on Rumble. So something to pay attention to, something to look forward to. Okay, how's everybody's weekend going thus far? Do I talk about mine? Nothing much happens anymore. It's one big freaking Groundhog Day that's been lasting over a year now. It's been a year. Our one blessing in all of this is that the kids are able to go to school during the week, which the blessing is not for the parents who get to have quiet time. The blessing is for the kids who get to have socializing time. But we're still under curfew in Quebec. This is, what's the date? March 7th. We are March 7th. The curfew was supposed to end February 9th. And we are still under curfew in Quebec. We're under, it was supposed to be a 4-week curfew from January 9th to February 9th of 2021. It was supposed to be a 2-week lockdown in March 2020. Okay, let me just do 2 super chats here. Book review. Someone said it to John Adams. There is no such thing as a good lawyer without a copy of the book of ethics and the law of nations on their desk. Does Barnes have this on his desk? Screenshot, and we're going to find out in a bit. Let's do, I'm not even saying this out loud because I don't want to violate any of YouTube's policies. Thank you for the super chat. I have my theories. We all remember the Eric Hunley, call it a debacle or a fiasco, but we remember that. I have my theories that the issue was related to digital monies. Tonight's stream did not show up in my recommends. Well, it's interesting. Thus far, we're low on people. Doesn't matter. It is what it is, people. We know how this works now. I have noticed, I think it's the post-election dip. I noticed a lot of people are talking about it, but things seem to be coming off a little bit of a spike from election season. But I also might be in YouTube's no good books. Although I won't complain all that much because it's still the biggest playground in the world. If anyone's gone to Rumble, let me know if we're still on Rumble. F for the shirt. The other one was a little too creased because I did not hang it up after the last stream. So we had to go with, this is still a Simon's shirt, fitted. I like it. Okay, so did not show up when I recommended. Well, that's okay. Share the links out now. I tweeted it out everywhere, and I think I didn't share it on Facebook. Whatever. Share it away now, and we'll give a few minutes for everyone to come in. What is on the menu for the evening? Before we get there, standard disclaimers. Thank you all for the super chat. If I don't get to the super chats and you're going to be miffed, don't give the super chat. I do my best. Robert and I split them 50-50. And I do my best to get to all of them, or at the very least, bring them up. If they are outrageously offensive or abusive, I might still bring them up but not read them, or I might not bring them up if they're going to get me in trouble. What was that? That's the first disclaimer. So don't be mad if I don't get to your super chat. Second disclaimer, nothing in this stream qualifies as legal advice. It is for educational purposes. You might get smarter. You might get angry. You might get more cynical, more jaded. Hashtag confession through projection, but no legal advice. Third disclaimer, actually, this is a good opportunity to talk about a bit of not a new direction of the channel, just where we're going. Before we do that, let's deal with another chat. We have time. I don't know what that says. It got censored off the Urban Dictionary. Okay, I don't know what that means. I'm going to go to the Urban Dictionary and look at it for myself. Also, I didn't get the recommendation for today's feed, and you're the only creator that I rang the bell for. I did see the Facebook video recommendation. Okay, well, that's good. Hey, in fairness to YouTube, I did publish a video today, which might have gotten in the way of recommended or reminding of the stream. So who knows? I published a video today. Facebook agrees to pay $650 million to settle a class action lawsuit based on an Illinois privacy law. It's a good video. It's one of my top performing videos. So who would have thunk something not related to politics would still be of interest, or not related to evil man Cuomo, which we're going to get to. Okay, so yeah, the direction of the channel. Everybody loves the Sunday night streams. I love them. They're amazing. It's homework throughout the weekend, but it's personal growth and personal knowledge. Robert and I are now starting to do Wednesday night interview streams. We did the first inaugural such stream last Wednesday with Dave Rubin, and it was great. I never appreciated how much hate Dave Rubin gets. It's not that much, it's like a small percentage, but it was more than I've noticed before, and I don't understand why, but I'm not filled with those types of emotions. So the first one we did was with Dave Rubin, and it was great. This Wednesday, we're going to go live with Mike Cernovich. Cernovich has been on my channel. If it's not 3 times, it's 2. I know it's at least 2. And it's going to be a good discussion. The month of March and pretty much April are booked, and there's good guests on it. And it's going to be phenomenal and phenomenally interesting. It's also going to be a tremendous amount of stress, because a good stress, like butterfly in your belly stress. I like the type of stress, because it's good to meet new people and have new discussions. Get your likes in early, like the simultaneous sip. It's the best part of the day. Speaking of simultaneous sip, I have water in an old cream jar. It's fun to have discussions with people, and this is the discussion. This is going to be my opening rant. 6 minutes, 41 seconds in. My opening rant. Maybe we'll do this every week. Who knows? I was having a discussion with someone who says, the people you interview and the people who come on your show are on the right. Balance it out with people on the left. To which I respond, I started this as a newbie, as a wet behind the ears, know-nothing schnook. I have always and will always remain open to pretty much everybody. What I've noticed over the last 2 years of doing this is that of all the invites that I send out, and the connections I try to make on social media, Twitter, etc., the books I read as an investment to a potential guest, I've noticed 90% of the people who don't respond seem to be aligned politically. And 90% of the people who do respond seem to be, I won't say aligned politically, but seem to be forcibly aligned politically. And it's a depressing reality that I've come to. And I'm weighing my words, but I would have people from the left as much as I have people from the right. I would have Brian Stelter on any day of the week. Might have to turn off the chat for that type of stream. But I know who I've sent out invites to. And I know who has said yes without a thought, without asking for questions, without asking for what we're going to talk about. And I know who has not responded. And it's a weird thing, but it's the way the discourse, the public discourse, is being molded and manipulated, is that you have forced political silos where people say, don't go on that channel, that's all right-wing guys. And it becomes a self-fulfilling prophecy. And it becomes a self-fulfilling justification to remain in your political and ideological silo. And it just seems to be a one side of the debate that avoids this type of interaction. And I say this with exceptions, because I've had, Nate Brody, people call him a lefty. I think he's more of a centrist lefty, but whatever. He's by far more on the left than anyone I've ever had on my channel. I've had Dershowitz on the channel. Tulsi Gabbard goes on other people's channels, but the second Tulsi Gabbard goes on right-wing channels, the second they do, the political left no longer considers them left. And so it's this vicious circle, self-fulfilling prophecy, creating your own definitions. The second a leftist or a person on the left goes slumming with the right, they are immediately castigated and set aside as being, alt-right. And Tulsi Gabbard, by virtue of the fact that she has a page on locals, is all of a sudden she's no longer left. So it becomes like a definition thing. By definition, the left doesn't interact with the right, and when they do, they become the right. It's very frustrating. Okay, that was my rant. Hey, Viva and Robert, time for an update on the Montreal lockdown and curfew and the lawsuits against the government, please. We're going to get there. And I'm going to do some super chats before Robert shows up and we bring him in. Detective listening in. Thanks for giving a lawyer's perspective, brother. Semper Donuts. Glenn? Whenever I hear the words detective listening in, all right, I'm subscribed and I had to go search for it. It doesn't even appear in your video section. That would explain a few things, but what can we do? Maybe I'll go check something out. Where are you moving, and why is it New Hampshire? Well, the meme nowadays is, if you could live anywhere in the world, what part of Texas would it be? We are going backwards in Canada, and it had better change direction fast. I didn't get the recommendation for today's feed, and you're the only creator that I rang the bell for. Okay, sorry, I think I picked that one up before. Okay, so I think I missed some chats here. Yeah, Quebec is going in the wrong direction, and so is Canada, at the very least from a civil rights perspective. From a numbers perspective and the charts, they seem to be following the same graph as the rest of the world. Oh my God, get Tulsi on a Wednesday chat, and you're my official hero. Who knows Tulsi, people? Let's tweet it out to Tulsi, and we can get her. I would love it. I would love to have Tulsi on. It would be amazing. You covered an ADF case sometime back. My father is on the board. If you like, I can get your contact info to their PR person. I can do that. Let's do that. All right. I'm gonna reach out for my contacts and try to see who we can get. We love Tulsi. Yeah, I like this. Tulsi is more center than left. It seems that anybody who's not. Whatever. I don't believe in these political divides, these political definitions, because I don't believe that I'm on the right by any means. And I know that people on the right would know that I have some views that they would not consider traditional right. Then I know people on the left would say the same thing. So we're in limbo, purgatory. What was I going to say? Bring the myth of legend Jordan Peterson on. What's amazing is once you establish a connection with certain people, you're 1 degree of separation, one degree of separation away from pretty much anybody. So it's cool. We'll see where it goes. The last normal Democrat. Okay. Any chance Barnes can give advice on how to pressure state and local government to be more open? DeWine isn't exactly being a Governor Abbott. We'll see. We'll ask him. In fact, everyone take a minute to share the link around if we haven't already done it. Doesn't matter. Maybe I could share it to my, when Robert gets in, I'll, you know what? Let me just do this right now. We'll go to community and I'll say, we are live now, period. Did you get the notification, ? And then we're going to go, yes. Let's add the option. Yes and no. Post. All right, let's see how that goes. I'm not doing that post as the gimmick thing to get engagement, whatever. Okay, I just see through the corner of my eye, Robert is in. Here's what's on the menu, people. It's going to be, they're always interesting, but some are more timely than others. Derek Chauvin trial starts tomorrow. And Chauvin is, for anybody who, I believe it's a last name of French origin, which is why Americans are going to say Chauvin or whatever. Chauvin is how we'd say it here. His trial starts tomorrow, I believe. We're going to go through, and that's the trial for George Floyd, and it's going to be national coverage, back to back, wall to wall, I guess. We're going to talk about that, get up to speed, and talk about how it's going to go down. We're going to talk about Voldemort, the name who can't be spoken, has filed a petition for cert. We'll call him AJ. In a file in which certain out-of-court statements were sanctioned by the court, and the question is going to be, is it constitutional? Were due process guarantees violated, etc.? It's a very interesting decision, and I don't want to get too far into the discussion before we even open it. Cuomo. Bad man Cuomo. We're going to talk about it. And we're going to talk not so much about the harassment stuff. Even in my follow-up video, I forgot to mention a couple of things which were material. Immunity being given to the nursing homes, which I want to see what Robert has to say about. I've lost track of my thoughts. It doesn't matter. And other stuff. There's going to be... Let me just get the menu. Forget it. Okay, let's bring in Barnes, and I'm gonna take this chat down. Sorry about that. Let's bring in the Barnes people. We are 14 minutes in. The Barnes is coming in. He's looking dapper. He's not wearing a tie, people. Robert, how you doing?
Oh, yeah.
Good. So, Robert, a bow tie for the first time ever. What is the special occasion?
Just that I got it. So, been trying it out. I used to wear bow ties as a kid. Then, they can be kind of tough to tie and annoying in different respects. But I do like them occasionally and decided to get some.
Very nice. Before we get started, someone asked for a book recommendation. Let's do the book recommendation right off the bat so we don't forget.
Sure. So the book review on Locals, which people can find at viva.barneslaw.locals.com, is
Right.
about this week is about the 48 Laws of Power, which I consider a worthy sequel to Sun Tzu's Art of War and Machiavelli's The Prince at giving strategic ideas. And it does it in a very effective way, shows historical examples of how it has been applied successfully, how it wasn't applied successfully. So it's where it's been transgressed and where it's been properly enforced. And it's it's just for it's an amoral book. It's not about morality. It's like The Prince and Sun Tzu's Art of War. It's about strategic tactical advantages that you can acquire anywhere in life. It's not unique to politics or law.
Okay, excellent. That actually sounds very good. Now, I am it's not a book recommendation. It's not a book review. I'm listening to Cernovich's Guerrilla Mindset. Primarily because we're talking with Cernovich on Wednesday, and I realize now that I probably should have listened to his book before the last time we did a stream. It's very interesting, common sense advice on self-improvement. It's
fantastic. I gave it to people. I gave it to my son. So I encourage other people to read it because it's just good basic mindset advice that's often critical and essential to how people function psychologically. I do remember I should give a shout out to the bow tie is in respect of Peter Lavelle for the show The Gaggle. He does it. He does the vest bow tie combination perfectly. So I'm trying to emulate it a little bit.
Someone said throwback to Tucker Carlson, but yes, Peter Lavelle, yes. The Gaggle has a great show. The Cernovich, it's funny because you listen to it, it's like, yeah, this is common sense advice, but sometimes it's actually just so foreign and so out of people's minds that they need to be reminded. And sometimes, the most important thing about common sense is just repeating it and remembering it. But there's good common sense advice in Cernovich's book, in Dave Rubin's book, in Scott Adams' book. So worthwhile. I'm about halfway through, and I go through about 1.5, so it should be done easily by tomorrow.
Scott Adams also has a Locals page. He does these little whiteboard behind the scenes presentations. He does the best charts. He did a chart today that was saying when to trust somebody, and all 4 was don't, and don't. Yeah, it was very effective. It was smart. I enjoy those.
Scott Adams is phenomenal. Let me see something here. We got, hey, Dave, I've been working as a medic for the last 10 years. There is a lot that can be commented on the Floyd incident from a first responder and medical POV. It won't all fit in a chat, but no need to continue with super chats to get that out. It's the segue into our opening and arguably going to be our biggest subject of the night. Okay, so, Robert, the trial starts tomorrow.
Yeah, presumably. Because there was a motion to dismiss because what Chauvin has been charged with. He was the officer who had his knee on George Floyd's back and neck and is considered the principal culprit for the death of George Floyd. And this trial will decide that. What he was originally charged with was 3 different criminal charges. The lowest level one was second-degree manslaughter, which carries up to a 10-year sentence. Average sentence is 2 to 3 years in Minnesota. The second charge was third-degree homicide, which carries up, I believe it's either 20 or 25-year potential prison sentence, and usually you get double-digit time. And then the top charge, second-degree murder, which was, in this case, felony murder, which carries up to a 40-year prison sentence. Usually you get more than 20. And so the third degree, the defense moved to dismiss both the second and third degree murder charge. The court denied the dismissal request for the second degree murder charge, granted it for the third degree murder charge. There was a parallel case that came up from a couple of years ago where a police officer in Minnesota had shot an individual who was completely unarmed, shot and killed her. And the question had just gone up in February to the Court of Appeals as to whether or not he could be charged with third degree murder. And
is that the Minnesota case with Noor?
Yes, that's Noor.
Okay.
So it hasn't got the same public attention, maybe because maybe because it doesn't play into certain convenient narratives that the press likes to push. But frankly, it was a more egregious case from my perspective.
This was I'll just give the brief overview. This is the cop. A woman calls the cops. Cops show up. The Noor is the police officer in the passenger side, who I believe fires through the driver's side window when he's startled because the woman who called the police approaches the police car. The woman was an Australian woman, passed away from her injuries, and I guess the matter got to trial 2 years later. Or
correct. And she was unarmed, and he admitted that he knew she was unarmed. He just got startled. Now, I do have, in my view, this case is a second-degree manslaughter case. It's not a second-degree murder case or a third-degree murder case under traditional interpretations of Minnesota criminal law. The way our criminal law systems work everywhere in America, is you have different elements. You go up the scale. And if you have a situation where second-degree manslaughter and third-degree murder require you proving the exact same things, that doesn't make sense because one carries a much harsher prison sentence than the other. And so what should be the case is you have one level of intent for second-degree manslaughter, another level of intent for third-degree murder, another level of intent for second-degree murder. In this case, second-degree manslaughter is called criminal culpable negligence, but for constitutional reasons, it's effectively the same as gross recklessness. So you have to know a substantial risk that your conduct is going to cause a person to die. And then you go up to third degree murder, and what it looks like is it's meant to be wildly reckless conduct. In other words, somebody that's driving a car through a crowd of 50 people, somebody who's shooting randomly into a situation, and that's why it elevates it. They want to discourage that conduct, that when you're not just threatening one person, but you're threatening tons of people, then you face a higher criminal penalty. That's the way our criminal laws work in general. And then you have second degree murder, which is felony murder, which traditionally you're committing armed robbery and somebody dies in the commission of it. When it was the kind of crime you were committing had a particularly high risk of a death, and death occurred, and so you're responsible. What's unusual here is I've never seen a case where they say that the felony murder charge isn't that he was committing a different felony, it's that his assault led to the death. I've never seen that prosecuted before, and it makes no sense because then you're duplicating the charge. By that definition, almost every second-degree manslaughter could also be charged as second-degree felony murder, and that's what's not supposed to happen. So I think that now the judge has sustained it for now, but I think on appellate review, if the courts are willing to actually look at the law, which will always be a big issue in a politicized case like this one, I don't think that the allegations of the indictment suffice to meet what second-degree murder is supposed to be.
Okay, and actually, before we even get that, let's back up just for 2 seconds. The trial that's scheduled to begin tomorrow is only for Chauvin. It's not for. Are the other 3 officers charged?
Yes, they are, with aiding and abetting.
Okay.
So the first issue was the motion to dismiss. The district court denied it for second-degree murder. So second-degree murder and second-degree manslaughter were scheduled to start Monday, with jury selection starting Monday. However, he had dismissed the third-degree murder charge, but because of the Knorr case, the Court of Appeals reinstated and said the court had to take another look at whether the third-degree murder charge should be reinstated in Chauvin's case. And there's always a possibility, if the court were to reinstate it, the defense may move for a continuance of the trial date. We'll see but I don't think the court's going to, because that Knorr decision is going to the Supreme Court. And if the Minnesota Supreme Court applies, the Court of Appeals decision in Knorr made no sense. They're violating the core rules of criminal law, which is different crimes, different elements required. You can't have a situation where the same conduct fits 2 different crimes and the same elements. You could have the same conduct find different elements by the jury, but not the same elements. I mean, what's the point? And they dodged. The Minnesota Supreme Court had plain language on this that said third-degree murder could not be just in its jury instruction interpretation. It could not be targeting just one person. And they're like, yeah, but that's in the jury instruction context. It was the dumbest decision I'd seen. It's a politically motivated decision, or just bad interpretation, whichever it was in the Knorr case. Now applying it in the Chauvin case. And so I think there's problems with trying to reinstate it. I think the case should go to trial on is second-degree manslaughter. It may go to trial on second and third-degree murder as well. Now, the severance is interesting. The other defendants moved to sever the case because they were charged with aiding and abetting 3 other police officers.
And that is to say that if Chauvin gets acquitted, then they don't need to go to trial.
Oh, no. They can still absolutely go to trial. His acquittal will not impact them. But the prosecution strongly opposed the severance. And I found that strange because if I was at least in Chauvin's case, I would want the other defendants there because the other defendants' conduct is far less culpable. You have a bunch of other lawyers who can present cross-examination and argument, and some of those police officers may testify, effectively making it unnecessary for you to testify. So because of their exclusion from the trial, exactly what comes in evidence-wise is probably going to be tougher from a defendant perspective, in my view. But the severance was granted so that their trial's not until August at this point. Okay. Now, go ahead.
Give me one thing. I did just before it disappears. Chris Pavlovsky, who is the CEO of Rumble, says nearing 200 watching live on Rumble. We are still short on features, but glad to have Viva testing Rumble's live stream in its early days. Chris, thank you very much. First of all, for the super chat and for the function. It's people very much appreciate it because people are looking to find alternatives to YouTube. But before we even just back up 1 second, if Chauvin, why would you not move to separate? If Chauvin is acquitted, he's found not guilty of the criminal accusations. How then could the other defendants be found guilty of aiding and abetting if there's an acquittal in the main charge?
It's inconsequential. I mean, I know that kind of doesn't make sense to people, but it's how you can be convicted of conspiracy and all your other co-conspirators get acquitted, right? See, often co-conspirators are not even prosecuted. So they'll get a second bite at the apple if they lose the Chauvin case. Now, I think the case against the other 3 cops is even weaker than the case against Chauvin. But the other motion that was brought pre-trial was a motion to transfer the case to at least have a different jury pool or transfer it out of Minneapolis.
Yeah, some people in the comment, I didn't bring them up, but said, good luck finding a fair jury. We've talked about jury selection in previous streams. What is going to be the process? How long are they going to have to select the jury? Is it going to be weeks, days, or hours?
Well, I think basically after the Enron case, it's going to be very tough for any defendant to transfer a case for venue purposes. And so it wasn't a big surprise that this court turned it down. But to a lot of people in the public, they find it very questionable how when you've had a city torn down by riots, when the potential jurors are going to be walking into a barricaded courthouse with fences and walls everywhere, where there was a shooting, I think, yesterday at the George Floyd Memorial in Minneapolis. So, I mean, it seems a bit questionable, in my view. If someone is clearly guilty, find a better venue. I mean, what's so hard about venue? I think it's problematic to try this case in Minneapolis, but it's going to happen.
Hypothetically, if you change the venue, how far do you have to go? Do you go to another city? These are federal.
I can tell you why the prosecution didn't want a venue transferred, because 2 prominent police abuse conduct cases, the Rodney King case and the Diallo case out of New York, were both transferred. Now, in that case, in the LA, they just transferred it from LA out to the Valley. In the New York case, they transferred it to upstate New York. But in both of those cases, many observers, they end up all acquitted in the state criminal trials in the Rodney King case, all acquitted in the Diallo case where they shot the guy, I think, 41 times or whatever it was, unarmed guy, immigrant from another community just walking into his home. So, I mean, in my view, both of those cases more factually egregious than what we have here, though probably many people don't know that because so many facts have been excluded from public disclosure about this case. But yeah, so it could be like normally what they would just transfer it somewhere else just anywhere in rural Minnesota. So you wouldn't have to go that far out. But basically, you within an hour of where the courthouse is currently, you also could just expand the jury pool to include jurors from there under these circumstances. But that's been denied. Now, one advantage from a defendant perspective of a case not being transferred is that what a court should do to substitute for pretrial publicity is give you much better voir dire than you would normally get. Much better jury selection. Voir dire just means Latin to speak the truth.
You're going to get nailed in the comment section. I think we say voir dire.
Well, that's how the French. That's probably the proper pronunciation. But in Tennessee, we say voir dire. So it depends on where you're from, of course, because it's Latin. It's not native to our language. Not really. And so part of that, but you should get much better jury selection because there's 2 areas where you have to do meaningful jury selection constitutionally. One is if there's been pretrial publicity, and secondly, if there's issues of racial prejudice involved. Those are 2 areas the Supreme Court recognizes there have to be detailed questioning. In the Snipes case, for example, based on various things I filed. It ended up being a lot of pretrial publicity about racial prejudice. And so the judge who said that he was going to pick a jury in an hour had to spend 3 days. State courts are usually much better at jury selection than federal courts are. In fact, tons better. It appears in this case there has been both a written juror questionnaire, which I always recommend because it gets you information you won't get otherwise, and then you get to follow up in person. Now, they're doing this under COVID protocols, so it's going to be interesting. I don't even know how they're going to seat the jury, given they're supposed to be socially distancing. So, I mean, I have problems with the idea that you can have a fair trial under social distancing rules in modern courthouses because they're not equipped to have jurors sit 6 feet apart. You end up with the jurors like sitting in the gallery. I mean, that creates all kinds of issues. It's just, I'm not a big fan of it. But again, the court's, marching forward on this. And so that's what's going to happen. Now, here's the hard part for picking a jury in this case. You need jurors from the defense perspective. Prosecution perspective is never hard to pick a jury. 9 times out of 10, they're already in your pocket. As a prosecutor, the prosecutor in the Snipes case told me why he loved Miami. He said, all I got to do is point to the flag, point to the Bible, point to the defendant, and say, convict. And he thought Ocala was going to be that same community, and just didn't go for him the way he thought. That's how that. So you get detailed voir dire. Here this is my guess. Now, presumably they've done focus groups. They, like I always recommend people like the behavior panel to be involved in jury selection because they can sit there and watch all the body language and get a read on things, on all the subtle unconscious communication. Most lawyers do horrible jury selection. They project their own prejudices on the jury. They, just read John Grisham. He has some of the dumbest takes on jurors that exist. And I'm a huge John Grisham fan. It's in order to, what you want here is really a unique mindset because people are going to come in with big biases, big biases. And ideally you want a jury that's heard as little as possible about the case. I know people think, man, that's going to be a miracle. Not so much. People will be surprised how many people pay absolutely no attention to any press whatsoever. So you want someone that's not influenced by the press, ideally. The second type you want someone with a unique mindset who's willing to be skeptical of the government and deferential to police. That is a very, very hard combination to get because anybody is usually skeptical. Because here you're going to have the prosecution and the coroner and police experts get on the stand and say, this guy committed a crime. This guy committed all these crimes. And in order to rebut that, you need someone who's going to be willing to be skeptical of the prosecutor, skeptical of the police witnesses, skeptical of the coroner, but deferential to police, because normally that personality that's skeptical doesn't like police, doesn't trust police. So that's the hard combination that they're going to need to get. We're not going to know much because apparently they are going to videotape the audio of the jury selection going on, but we won't see the jurors and we won't see the questionnaires. So we'll have no idea how good or bad the jury is, us that are observers. Mm-hmm. And so we'll find, but I think he needs a unique jury. I think he can get it out of Minneapolis, but I think it is an uphill thing to get.
2 questions. First question is, you're going to have a questionnaire to fill out. I have no idea how this works. Does counsel, defense, and prosecution work together to prepare it, or does only defense have the luxury of preparing it? The written questionnaire to test them, is it generic? Is it done bilaterally or is it done unilaterally?
Has to be approved by the court. So the court decides what questions get asked. The court controls everything with the process. So the court, usually you can propose questions, both sides, but the court decides what questions get asked, how they get phrased, how many get asked, all of that. Then when you're on and then some courts, this state court probably will allow the lawyers to ask questions of the jury. In federal court, you almost never get to do that. Now, what's interesting about the Roger Stone case is it has cleared up an area that's been occasionally confused about the issue of what kind of research you can do on the jury. So, like in the Snipes case, I had the files of every human being that could appear in the case digitally accessible to me, so that I didn't have to look them up after I got their name. But at the time, there was because here's the controversy: you find out somebody's a juror, you go and Google that person. You come across their Facebook or Instagram or social media feed. Well, under some ethical rule interpretations and some technologies, when you look at that juror's file, the juror gets notified of it, their social media page. Is that illicit contact? This is what they blew over in the Stone case. They're like, why didn't you look at everything? It's because for years, defense lawyers have been warned to be very careful what they look at and when to look at it. But now that court said that and said it's your ethical duty and obligation to look at it, I don't want to hear any more courts complaining about this. Because these days, your social I'm sorry, go ahead.
No, I was going to say that for people who may not be aware of this, you probably are, but you can see it, for example, on LinkedIn, when someone views your profile, unless they've turned that feature off and it says someone, you can see who's been looking at your profile. So, and you make this mistake as a lawyer exactly once, because you don't even have to do it for an opposing party or ethical issues. You just might want to know who you're contracting with, who your client is contracting with. And when they see, the other guy's lawyer viewing their LinkedIn page, well, then their hackles go up in all respects. So for anybody who doesn't know that, life pro tip, turn the function off. But and now what is the status now? Are lawyers allowed doing it, or is it still considered illicit contact, which is why lawyers farm out that work?
Increasingly, it's recognized as permissible. And the Stone case sort of solidified that, because the court was like, it was up to you as lawyers to look up the jury foreman's entire Twitter feed. Okay, I'll take that as a green light henceforth. And I'm not hearing any courts complaining. Don't turn around and say it's your duty and ethical obligation, or it's malpractice if you don't do it, and then turn around and say it's unethical if you do it.
And for anybody, people may not know even what we're talking about in the Roger Stone case. That was the case in which the jury forewoman, who was the forewoman with a large degree of power, I guess, and influence over the jury, it was later revealed had posted numerous anti-Trump, I guess to some extent, maybe Roger Stone by extension. I don't want to oversell it, but she was quite political on Facebook, and it all came out afterwards.
And on Twitter, I think, too.
On Twitter. And she apparently was not transparent on the form that she filled out, but ultimately, all of it without consequence. It just colored people's interpretation of the impartiality of the jury. So that's the context for what we're talking about.
And the prosecutor in court's excuse for the jurors' what appeared to be misconduct to me was, it's up to the defense to have found that information. And I was like, interesting. So now, if you're smart and sophisticated, you have a whole team. You have a behavior panel. Now, sometimes cost is obviously a factor, but you have a behavior panel type people involved. You have other professional jury consultants involved. You do forensic handwriting analysis on their handwritten answers. And you have a Richard Barris type, the People's Pundit, who has huge voter files on all kinds of people who can tell you tons of information, what magazines they subscribe to, what their whole social media footprint is. All that information's, people don't know this. It's all gathered on you, folks. You leave a lot of breadcrumbs. But if you're a good lawyer, you'll have researched that. And by the standard of the Stone case, you almost are ethically and professionally obligated to now. And that will give you a big, big path. I remember I had a big case against Wells Fargo, and I employed every resource we had, and we picked a great jury. And once the Wells Fargo lawyer recognized who the jury was, he immediately started trying to sandbag the case, accused me of discriminating against white people, which was funny. But he realized, hold on, that this jury pool is exactly the wrong jury he wanted. That case settled soon thereafter. He actually tried to blow up the case, do a inflammatory opening statement, hoping I would move for mistrial so he could get a new jury. I did not move for mistrial very quickly for that reason. But yeah, so but I don't know how good it is. Most defense lawyers do a poor job of jury selection. So, but that will probably take 2 weeks. We probably won't get into evidence until the end of March.
Oh, 2 weeks. Do we have any idea what the evidence is right now? Like, we do know that there are 2 coroner reports that, from what I understand, say 2 diametrically opposing things.
Kind of. So here's the backstory. Like the evidence, the prosecutor's presentation, opening statement's really kind of basic. Now, here's another fascinating thing. They've hired outside private counsel to be the prosecutors. So it's not the attorney general. It's not the district attorney. They went out and hired 2 of the top private trial lawyers in Minnesota. I have never seen this before. Now, personally, I would love it if private counsel were prosecutors like they do in the Australian system, because there would be more obligation on them to be ethical and professional. But to do so just here shows you how much resources they're dedicated to convicting Chauvin. I mean, he's facing much more sophisticated counsel than if it was just the local DA's office or just the attorney general's office. He's facing the best trial lawyers, plaintiffs' lawyers, corporate lawyers, and state lawyers all working together against him. But their opening statement's relatively basic. It's what the media narrative has been, and it's that Chauvin came in, put his knee on the back of the neck of Floyd for 8.5 minutes. He did so even after Floyd, for several minutes while Floyd was not moving. Did so even after Floyd said he couldn't breathe for several minutes. Did so even after another police officer said, shouldn't we roll him over? What about rolling him over? And did so even though current training protocols in Minnesota required that or recommended you turn the person over once they're no longer a threat to be violent or anything else. So that's basic presentation. Now the defense presentation for the top two charges are kind of legal because there is no felony murder here in my view, and they have, I think, a very good legal argument on that. And depending on what jury instructions they could get, they could win by just saying there's no other felony here. So this just isn't felony murder. And third-degree murder, if that's reinstated, doesn't fit because this was justice to this individual. It wasn't wildly reckless conduct.
Sorry, actually, to stop you there, to simplify something you said before, I think. So the idea of felony murder is you're committing a separate act from assault per se. So robbery, I'm trying to think of something that do not involve assault.
Oh, honestly, it could be any of it. It can be drug deals. It can be, you're just committing a felony period, which a person dies. That's all they need. I mean, in my view, felony murder is a grievously abused criminal statute. People get charged with felony murder that didn't have anything to do with the person's death. So my thought was, like in the Arbery case, my understanding is their felony murder theory, and I assume they were doing the same here until I realized they weren't, was that they had kidnapped a person and then the person died in the process of a kidnapping. That's an example of classic felony murder. I've never seen them say, I mean, by their definition, okay, I have a gun, I shoot it at someone, that's both assault and murder, I can charge felony murder. It makes no sense. It makes a joke of the Minnesota criminal statute.
So that's the interesting question. So the idea would be that if in the ordinary run of criminal law, if you end up killing someone during an assault, it can be either murder, manslaughter, or I guess murder or second degree.
Right.
If it's a second degree, this theory that it could be felony murder.
Second degree manslaughter.
Second degree manslaughter. So the idea here would be why you're saying this makes no sense is if you turn second degree manslaughter into a situation where you can also then just go with felony murder, you've effectively unwritten second degree manslaughter.
Exactly. You've negated the entire purpose of the criminal statutes, which is to treat different conduct differently. If you can treat second degree manslaughter as indistinguishable from felony murder, that's a problem. They've also done the same thing now with third degree murder. Because once you understand that second degree murder, even though it uses the language of culpable negligence for due process reasons, this goes back to Henry Winship and other cases, requires a certain level of criminal intentionality has to be established to prosecute and punish people. We generally don't allow negligence to be prosecuted criminally. Is that it has to be you read the definition of the Minnesota statutes, it's identical to how they're down defining third degree murder. It's identical. There's no difference in the elements now. None. Because both of them are substantial risk, according to the court's recent interpretation, substantial risk that you're going to inflict harm on someone, that you could cause someone's death, substantial risk of great bodily harm or death. It's now identical, which doesn't make any sense to me. So I think they have good legal defenses on second and third degree murder that might translate to jury instructions that are favorable to them at trial. As to the second degree manslaughter, a lot of the evidence for the defense is evidence most of the public has not seen. So most of the public does not know of the background of Floyd's background in general, which may or may not come in evidence-wise. So the defense perspective is going to be this: George Floyd was had a long criminal history, a long violent criminal history, including armed robbery, put a gun to a woman's stomach. There's some misinformation out there that she was pregnant. I haven't seen any evidence that was the case. But how much of this evidence comes in is an open question, because the key is going to be, how does the cop say, what is Chauvin knew Floyd before, apparently. So it's possible that Chauvin can testify he knew of this history and that this is why he approached him as a uniquely dangerous person. So part one is the extensive criminal history of Floyd. One of the other detectives' lawyers wanted to introduce a 2019 arrest of Floyd in Minneapolis, where he employed similar tactics. And the defense theory in that case was the reason why that 2019 arrest video was relevant is because it shows what their argument's going to be. Is it shows Floyd using, oh, I'm scared, I'm afraid, I can't do this, I can't, as a tactic to try to both prevent arrest and get rid of inculpatory evidence. And because he almost behaves identically then to how he behaved now. So those two, but those, whether that comes in evidence-wise, big open question. Now, sorry.
I was going to say there's two things. This is the discussion we had way back, and I think I've had it with Nate and on civil law as well. And it was something about Candace Owens said a while back, that there are two different things here. As far as I'm concerned, the criminal history of the individual can become relevant to the incident, as you said, pretty much if and only if it was factored into the rationale of the cops in approaching him. The fact that he had a criminal history in and of itself, if they didn't know at the time, is irrelevant.
Correct.
What comes into play, the drug use, et cetera, where the drug use, whether or not he was on drugs at the time, typically can explain a few things, but where it will be determinate here is if the intoxication was a contributing factor to him passing away from the knee to the neck, which might have otherwise not caused that reaction in somebody else. Then it becomes a legal question. Regardless, you take the victim in the state in which they come, and so if he's high on drugs, the policeman should know better than to administer something that is probably not ideal to administer in any circumstance, but even more so to someone who might be high on methamphetamines or whatever he might have been high on at the time.
Yeah, that'll definitely be the prosecutor's argument. The defense side of the equation will I'll get to. What is likely to come in is the video of the whole arrest. Even though Chauvin was not there for part of the arrest, so there's a question as to whether all of it will come in. But there it appears that one of the other detectives officers was able to show that what it appears that Floyd was doing was two things at the time of the arrest. That while he's saying he's afraid for his life, and because here's the core narrative for folks out there from the defense. It's going to be, why didn't they take George Floyd? Why weren't they like, oh my God, this poor guy, he's saying he can't breathe. Why didn't they immediately step back? Their explanation is going to be he kept making up different excuses at different times for why he couldn't comply while he destroyed evidence and resisted arrest. That's going to be their narrative. And they do have evidence for it that the media has not generally publicized. In fact, the prosecutors went to great lengths in this case to try to keep the 2019 arrest video from being released to the public, went to great lengths to try to keep the body camera evidence from the other detectives, didn't want that released to the public. Highly unusual. And they've actually gone to great lengths to request that this trial not be video broadcast, which is a little odd. But what it tells you is there's a whole bunch of evidence that prosecutors know makes their case look a lot weaker than the ordinary person knows out there.
Well, an interesting thing though, if there's going to be evidence to the effect that Floyd was making up excuses, that if he, and the idea being he could actually breathe, he was just saying I can't breathe as an excuse. Well, that might make it, in my mind, even more damning of the causal relation between the knee and the death. No, I mean it's.
What do you mean?
Well, if he says if he could in fact breathe, and he was just making up, he was using it as an excuse to get them to stop doing what they're doing, and then he did in fact die as a result of what happened. I mean, what's going to be the rationale that he could in fact breathe, but somehow he died of something else totally spontaneously?
It's not so much an objective factor as to what caused his death. In terms of that theory of defense, that theory of defense is all subjective state of mind. That why, like Piers Morgan had this interview with one of the criminal defense lawyers where he got to virtue signal and grandstand and attack the lawyer, but largely because Piers Morgan doesn't know the core facts in the case. To him, it was clearly the best evidence of intentional homicide was the fact that they heard him begging for his life, saying he couldn't breathe, and they didn't do anything. So if you're the defense, you need to contextualize, why don't you interpret that as, oh, we got to take emergency action? Okay. And from the cop's perspective, it's going to be, the guy's been giving me different excuses the entire time. One minute he thinks I'm going to shoot him. The next minute he can't, he's claustrophobic. The next minute he starts apparently saying he can't breathe before he's even on the ground. So though that's what it's about a subjective mentality defense. And for folks out there, I'm not saying what I believe. I'm presenting what both sides are going to present. I don't have an opinion on the case beyond what I've already said. But what's key is if you watch court TV, the lawyers on there, longtime criminal defense lawyers and even ex-prosecutors, have a very different view than what everybody's hearing in the press. And it's because there's a lot of weaknesses in the case that have developed. Here's the biggest one. The study showed that this method of detaining individuals had been employed hundreds of times in Minnesota in just the prior 5 years. And it was unconsciousness was not uncommon, but death was unheard of. So what these officers are going to be able to say is this is commonly employed. We were trained to do, well, this is what Chauvin's going to say. This is how I was trained. This is how people do it around the world. Indeed, people are put into that position tens of thousands of times around the world by police departments. It's now controversial, but it wasn't that controversial at the time. If you were a civil rights lawyer, you knew it was controversial, but most people did not. Most police officers, frankly, did not. And so that's why they still had it in the manual, and then they tried to memory hole the Minneapolis manual and make it disappear.
That was exactly what I was just about to ask you. Someone in the comment section said that the police station apparently, or the police, wherever it is listed as protocol, removed it from the website as standard protocol. I don't know if that's true or not, but
yes, absolutely. They removed it, and they removed the whole. You had to find it. It took great efforts to find it, but the defense has found photos of training manuals from slides that show worse footage than what happened with Floyd. And here's another parallel to this. The best example of this, the 8th Circuit in 2020 said that you couldn't even sue a police officer who put somebody in that exact position with the legs shackled, with their knees on the neck for 15 minutes, almost twice as long as Chauvin did. And the guy died, and the guy complained he couldn't breathe. The 8th Circuit Court of Appeals said you can't even bring a civil rights case on that because that's within the reasonable exercise of a police officer's duties. So those are things that may come in because police officers track those cases because they're told about them by their union. So if you're sitting on the jury, you've been told that position is horrible. You're putting your knee on a guy's neck for 8.5 minutes. What happens when you find out that's part of training? What happens when you find out that they've done it hundreds of times and nobody ever died? What happens when you find out that the 8th Circuit Court of Appeals said that's reasonable police officer conduct? These are things that the press thinks that if they gaslight the country into not knowing, that somehow you can keep it out of a jury trial. And you can't keep it out of a jury trial. I mean, the court could try, but the court has shown no inclination to go that route.
No, but you can't necessarily keep it out of the jury trial. But if you keep the jury trial off the airwaves, then you can keep that information out of the knowledge base of the general public, so they can be outraged if and when there's an acquittal that the View gets to freak out over. And
this attorney general is the guy who put a photo of him with Antifa's book and bragged about it. That's who this attorney general is. So and this is a case going back to the coroner's report issue. So there's intent legal issues on second and third degree murder. The issue about whether it's reckless homicide is they have to show that Chauvin subjectively, there was a substantial risk of death by him doing what he was doing. The evidence that it wasn't is that this was custom and procedure that had been approved of by federal courts, that he had employed for 15 plus years, that nobody in Minneapolis knew of a single death relating to it or being caused by it. So that's his best defense. The best counter to that from the prosecutor's perspective is going to be that once the person is no longer a threat, you're supposed to roll them over on the side, according to that Minnesota training. That's his biggest evidentiary hurdle.
Yeah, that and the three other, I don't know which ones, one of the three or two of the three or three of the three other officers expressing concern at the lack of responsiveness. And then Chauvin continues for a few more minutes.
It might be a causation issue, right? What if he was already dead by that point? So if he was dead by, say, minute 5, that he's on his neck, does anything that happens after minute 5 matter? Probably not, right? Yes. So the other big issue in the case is going to be causation. So there's two issues with it. One is that this particular method rarely leads to death, and that it didn't have the normal indicia. You didn't have a crushed. I don't know all the medical terminology. You won't pretend I do, but I just looked at the common things they usually use to prove that the knee on the neck caused the death. Those are not present here. Now, nor is the normal things that are assigned to ODs. So he had a fatal level of fentanyl in his system, and it appeared he did something called a goofball. It also appears they have video footage. Apparently, one way he was trying to get rid of the evidence, because he was trying to get rid of the counterfeit bills because they found him crunched up later in the car when he was trying to buy. I think he was trying to buy time. I think that's what the evidence the jury will believe he was trying to do that, which it's going to change the filter on things a little from what the media narrative has been. It's why the media has almost never covered that fact, that they found crumpled up, like, what? Why didn't he put his second hand on the wheel? the reason why the cops started getting really nervous. He's only putting one hand on it's because he was trying to get rid of the counterfeit bills because they find him crunched up later in the car. But the other thing he apparently did is they have a slow-mo photo of it appears he took a shot of fentanyl and they have him in his mouth that he was trying to do that quickly before they could find it on him. So he may have done the shot or done the drug right at the time. Now, the thing with all that is, so these goofballs can cause the same kind of death that he suffered, but normally you see other physical indicia of it. So there's going to be a lot of medical experts on both sides in this case. I think the prosecutor has 4. They have like the coroner. Now, the issue, as you note, there's an issue with the coroner because the reason why the Minnesota Minneapolis DA's office is not bringing the prosecution is because they decided to do a secret meeting with no witnesses present with the coroner. And from a defense lawyer perspective, usually that's to help make sure the coroner comes to the right conclusion. Because other people that have looked at this, even people that think Chauvin should be convicted, that are in the medical community, that have been on YouTube or other media places, have said that if all you did was look at the paperwork here, the toxicology report and the autopsy, you would probably conclude drug overdose. It's only when you've seen the video or know about the video that you conclude that's the reason. Now, there was a second autopsy done by Floyd's family that says they believe there's more physical evidence of it being a direct cause of the knee on the neck being a direct cause than the coroner said. So, but cause of death is going to be big because in order to show convict him on any of the charges, they have to show that he was a substantial factor in the death. Doesn't have to be the sole factor, but does need to be a substantial factor. And given the level of drugs in his system, there's going to be an inference. And the best evidence they have, really, in my view, isn't so much that he also had a heart condition, other issues. It's because it's the evidence that this is very rare, that a knee on the neck that doesn't cause certain injuries to the neck, to the breathing mechanism here. It's very rare that causes death. That's probably their best evidence. Defense's best evidence is going to be he didn't show the physical signs of an OD. Face didn't turn. He didn't go limp. His face and fingers weren't, nothing was turning blue. Some of those indicators that are commonly present. But it appears what he did was called a goofball. I didn't even know what this thing was, but I'm illiterate in the drug world. I don't have Hunter Thompson's skill or experience in that regard.
Okay, here's the thing to back it up. If anybody in the chat, if this is not correct information, then do correct. Is it accepted from both sides that he had a lethal amount of drugs in his body, or that he just had elevated amounts?
No, there was a fatal amount, but not that it caused the death. That's what the dispute is. Because it wasn't just fentanyl. Fentanyl was the level he had in fentanyl, and fentanyl is an incredibly dangerous drug. I mean, 80 to 100 times worse than heroin in certain contexts. The level he had in him, like as soon as people saw the toxicology report, and this is something else they tried to suppress for a long period of time, people were like, whoa. People who are much more knowledgeable in that area than I am were telling me, oh, I'm sure the drugs killed him. But then when I was researching what the likely evidence would be, seeing a lot of medical community people saying, well, he didn't show the physical indicia that you would normally see from a drug overdose. Now, there was some sort of breathing condition they were describing. I didn't dig enough into it that could fit the description. But there's basically evidence inconsistent with both theories of death. In other words, both with it, there should be certain evidence that's not present if the knee on the neck caused the death, and there should be evidence not present if the drug overdose caused the death. And so I think, but it's enough to probably raise a reasonable doubt if you have an impartial jury. Well, I think if he got a truly impartial jury, long story short, I think Chauvin would get acquitted of all 3 counts. I don't know if he will get such a jury.
Well, before we get into which way the jury will be impartial or partial, I should say, going back to the eggshell defense, you take your victim in the state that they come. Is it a double-edged sword to say if they're going to say, I saw him try to swallow the drugs, I knew that he had tried to swallow a goofball or whatever. If the cop's defense becomes, we saw him consume the drugs to hide the evidence, which is why we did this and that, do you have to take someone in the state that they are in if they've just consumed the drugs and treat them differently?
Yeah,
I mean, I know ways, because if he's in a state of, what do they call it? Delirium. What's the word I'm looking for? Excited delirium.
Yeah.
Then he can be even more of a threat, and in which case you might have to use more subduing tactics. If you know that he's just done a lethal dose of something, maybe you need to get into the hospital right away, but he's not. So does that cut both ways?
Well, it depends on what drug they thought he had. And if they thought it was excited delirium and it was PCP, this, by the way, was the Rodney King defense. That the reason why they kept attacking him was they were saying they had to keep attacking him because they thought he was on PCP and just wouldn't stay down. And remember, that was much more egregious conduct than what happened, at least in my view. I think it's fair to say. I mean, putting your knee on the neck is something that shocked a lot of people. But Rodney King, I think, would shock more people. I mean, eight guys sitting around beating you beating you and kicking you.
If anybody, it's not a video that anybody should see, but we grew up. I mean, we were roughly the same age back then. That I remember traumatized me. I mean, I saw the video. It's very, very little that anyone can use to explain that. But yeah, this did shock me as well. And I say this with not the blindness, but rather the viewpoint that I was still seeing this through the news. I don't know when I became aware of the toxicology report, but I did remember thinking, okay, when both coroners come up with sort of different conclusions, it confirms my theory about experts, etc. But I was not aware of many of the facts when the initial story broke. I suspect a lot of people in the chat are probably learning some stuff that they didn't know either. Most notably, the fatal levels of fentanyl in the system, which I did not know.
I think the two pieces of evidence that favor Chauvin the most are, one, how common this technique was used without it causing death. And secondly, the fact that, I should say three pieces. The second being how much Floyd fought back when he was inside the car, that the body cam footage showed. And then third, I mean, he was physically, it was almost impossible to keep him in the car. And then third was the degree of his toxicology report. The evidence that hurts Chauvin is the length of time he's on his neck where he doesn't appear to be pushing back or fighting back at all. And then the other big problem for Chauvin is if his record comes in. Because I remember when we first talked about this, I said, if Chauvin, if I would be skeptical of Chauvin's intentionality if he has a history of complaints, just because in my experience in civil rights cases and before all the cop, well, if you want to troll me, you have to go to Viva Barnes law.locals.com.
You are
there's no guarantee that I'll read your comments elsewhere.
You are the best at plugging locals. I'm 10% of your ability to do it, but yes, you can get to us and Barnes in particular.
And then you can troll me about anything you want, take whatever pot shots you want. But but in my experience, I know all the cop folks out there might get agitated, but in my experience, when someone's got a long list of complaints, it's rare that 5% of officers or less have a dozen or more complaints against them. It's just, people claim to me it's commonplace. It hasn't been in at least my litigation experience. I have not seen it when I've looked at the records and information and when I've done FOIA requests and the like. So maybe something's changed. Maybe something's unique to Minneapolis. But when I saw that, I was like, I would have doubts. It also might put pressure on him in terms of testifying. He has other risks because he's currently facing criminal tax prosecutions because apparently he didn't file returns for many years. And his wife's got risk. There's probably corruption issues. That's why I think no matter what happens in this trial, Chauvin's done. His ability to defeat all these things, very low. Not only is his job over, he's going to go to jail or prison on something. And that's why I thought the real person to blame here is, in the end, Attorney General Barr, because Chauvin was willing to plead guilty and do a 10-year stint for this to wrap it all up that would have given him the conviction that he needed rather than gamble on what a jury will do when they see all the facts. The other thing is, I can tell you from doing these cases, jurors get mad when if they have a jury that has been exposed to the pretrial publicity, gets seated anyway, they get mad when they discover they've been lied to by the media. And it starts to make them doubt everything about the prosecution. That's why if I was on the prosecutor's side, I let my weak links of the story come out early so that I see how they get absorbed, see how they deal with them. And I look like I'm the truth teller, the truth giver. I come in with that assumption if I'm a prosecutor, just the opposite of your defense lawyer. But I think people are going to be shocked by it. There's a reason why the prosecutors did not want the public to see this trial. It's because a lot of evidence is going to come forward that's going to raise serious questions about what they originally assumed was true.
Okay, that might do it does it for now for the preview and where things are going to go. I mean, I guess by next week's stream, we'll know more and we'll have more to follow up on if there is. I think I've got all the questions out there. If anybody has any more questions that we didn't get to, let me know. But I think now might be time to move on to something along the same lines of egregiousness. Do we do Cuomo? Because I have a few questions that have been driving me nuts. Everybody knows what's going on with Cuomo. I was with Eric Hunley, and we were talking about
podcast for everybody out.
But I'm getting mixed up with streams as to who it was that we were talking about. Cuomo.
You're on there with Good Logic, who's good. He's got his own YouTube thing now. Definitely go subscribe to his channel because he does need some new TV equipment. And Nick Rekieta, who will be a featured guest on our Wednesday weekly guest series we've started.
Just so everybody knows, Nick Rekieta is coming on. Joe Neerman, and it's Good Logic, Lawgik. But I'm totally senile. It was actually on my channel with Ian Corzine.
C, isn't it? Good Logic with a C.
You'll find it. It's Lawgi, either C or K. But the discussion about Cuomo was actually on my channel with a stream with Nate and Ian Corzine, another lawyer on YouTube. And I think I'm less interested in the workplace sexual harassment stuff. That's par for the course with politicians these days, it would seem.
Well, that's the Chinese water torture that Kamala Harris, whoever's behind this, is using to drive him out. But his big legal risk is the nursing home issue.
Okay, so now we're going to go back to the beginning on this because we talked about this months ago. I mean, we talked about it months ago. For anybody who doesn't know, at the time in April, I think it was March or April, Cuomo and others, Whitmer, Wolf, they signed executive orders that were requiring nursing homes to accept back people coming out of the hospital, discharged from the hospital, who were COVID positive. And apparently, at the very least with Cuomo, they were prohibited from administering tests to see if they were still infectious before bringing them back in. We'll talk only about Cuomo's case, and we'll see if there's any analogies to the others. Cuomo does this, brings in however many. I mean, they had numbers like, I think it was 9,000 that they readmitted back into nursing homes, who subsequently infected the nursing homes because it was the place, not just in New York, not just in Michigan, Pennsylvania, in Quebec and Canada. That's where 70 to 80% of the fatalities occurred. And that's where the spreading occurred as well. In New York, he admitted, close to 10,000. I think it's 8,000 patients back to the nursing homes, infected the nursing homes. Then they started having a rash of deaths in the nursing homes and elsewhere. And what ended up happening is a lot of the people who got sick in the nursing homes were put in hospitals, and they subsequently passed away in the hospitals, except Cuomo immediately after there was a firestorm from this policy, changed the way they counted nursing home deaths and started to exclude the deaths that occurred in hospital. One of the arguments is going to be that it doesn't make a difference. The aggregate number, it doesn't make a difference where it occurs. If it occurs in a hospital versus the home, it doesn't matter so long as the aggregate number is accurate. Others are going to say, well, if you're increasing the spread by the practice, which is what one of the articles said, is they increase the spread not only in New York, but potentially nationwide, by, infect there, put them in the hospital, continue the spread, downplay, or at the very least, fuzz where the spread is coming from, where the deaths are coming from, which is the accusation that now Cuomo, in fact, sort of negatively affected the rest of America, because the virus, the strain that spread in Texas, Louisiana, elsewhere, was the New York strain, not the West Coast strain. Those are the facts. That now, when we know that Cuomo delayed responding, providing numbers to the Department of Justice requests because he didn't want the numbers being used against him, delayed giving the numbers to the state for the same reasons. And there was one thing. So that's the facts. The one question that I have is, early on, we talked about it. He had given immunity to nursing homes. Do you know the context of how, why, and what the rationale was for giving immunity to nursing homes? I don't remember if I knew it.
Well, it's something they've been done. There was no good rationale, but I mean, the nursing homes wanted it because they felt they were being forced to comply with certain policies that might expose them to legal risk. And the nursing homes and people related to nursing homes are big contributors to Cuomo and the Democratic Party in New York. So, because I had clients who wanted to sue for their parent or grandparent dying in the nursing home from these policies. And in all these Democratic states, Maryland and other places, they had come in and immunized them, said you can't sue them for anything related to COVID. And so it was very little discussion of it in the mainstream press. And there was very little rationalization of it that I saw that that any public policy could justify. Because it was, what they created was, okay, I'm going to order you to do something. I'm already immune under sovereign immunity, and now I'll immunize you. So I've created this perfect circle where nobody can be sued for this bad stuff we're doing. And now I think where there's two issues. One is that early on, the CDC corrected itself and made clear not to do this. And even after that point, Cuomo continued to do so. So he only has the CDC as an excuse for part of the time. The other analogy I give to people is go back and look at what all the lawyers, legal experts on the left said when they thought Trump simply didn't disclose who in the White House had COVID and went on a trip. And they said he should be criminally prosecuted tomorrow for mass murder. Well, what Cuomo did was actually mass murder. Why are they all so silent right now? Why are they all so high? That shows what frauds, fakes, and phonies all these legal experts really are, because their political bias just consumes them. This is much closer to that. Now, is it hard to prove from a criminal perspective to show that? Well, as you pointed out, they just did it to the governor of Michigan for what he screwed up on just poisoning the water. So this was much, much worse. If once that political process has been, or prosecutorial process has been weaponized in that way, there's no reason why Cuomo can't be prosecuted. And now the easiest way to prosecute him is all the cover-ups. He likely submitted materially false information and obstructed inquiries into what he did, and that's almost always a crime, and it can be both a state and federal crime. That's why right now he's under criminal investigation by both the federal prosecutor in the Eastern District of New York and the state attorney general. And the political background is a lot of people were saying, oh, nothing's going to happen to him. Look at what happened to Democrats in the past. Look at what happened to the Virginia Democratic governor. They don't understand there might be powerful people afoot who want to see Cuomo's political career killed. They want to see what happened. They want to see his political career go the route of grandma in Cuomo's nursing homes. And that's why I think he's at real risk.
Well, and now people were saying also, people are saying three things. Everyone views this through politics. They say it was Democrat states, Whitmer's Michigan, Wolf's Pennsylvania. Who's New Jersey? No, I don't remember. But they're saying it was these Democrat-run states that had this problem. That may be true in the states, although I think there may have been. I don't know if there's other Republican-run states that had similar outbreaks in nursing homes. That was sort of the universal spreading point everywhere. In Canada, nobody was letting this happen so they could make Trump look bad. People are saying, Cuomo did this, Whitmer did this, Wolf did this, so that it would reflect poorly on Trump in an election season. I won't go that far.
There's an argument for that, but no, I don't think that was the driving cause. The driving cause was they wanted to do what they wanted to do and ignored certain medical evidence when it hurt them. And when they got caught, they tried to hide it and cover it up. And the question is there going to be a consequence when they have? I think there's potential issues of at least implicit bribery in terms of these political donations from nursing homes given special immunity afterwards because of these deathly policies by these politicians.
I guess the idea is, why give them immunity if it's not a risky thing in the first place is the one thing. Was there immunity given in other states like Michigan and Pennsylvania? And is there any evidence of failure to disclose numbers in Michigan and Pennsylvania like there is in New York?
We don't know that yet. And that's why I think certain people are behind this. So the certain vice presidents that may exist, that may currently be the vice president, may not see the governor of Pennsylvania or the governor of Michigan as much of a threat, whereas they might see the governor of New York as a major threat. And that may be why there's such focus on him. But I would be surprised if something similar didn't also happen. And Jack Posobiec was detailing very early on. He's another guy that's going to be on one of our future weekly interview series. He was one of the first people to rat this out. And he was documenting it in Pennsylvania. And that person is currently up for a high-ranking position. That was the person, remember, she, born a he, now a she, is the person who took her own mother out while she was sending other people to die in nursing homes. Took her own mother out of that facility. And she's now a high-ranking Biden administration official.
I never put the two and two together. That I remember that story coming out at the time. I had no idea. I was so young and naive to all of this. I didn't know names and I didn't know anything. I never put that two and two together. It's beyond hypocrisy. It's beyond rules for thee, but rules for me, but not, you know what it is. It's beyond
criminal negligence on a massive scale that killed lots of people for politicized purposes, ultimately. And there should be some legal consequence somewhere. And one of the things they should do is remove these liability limits, at least on the politicians that were involved in it.
Let's see here. I will go that far to accuse Cuomo. It's.
I mean, there were other people who did it, but people like me were tweeting in March that we needed to protect the nursing homes. So this didn't require a medical degree to figure out. You could just,
That's the other thing is the CDC's recommendation is one thing. I mean, the defense might serve for a certain period of time, but we were talking about it here. Like the outbreaks were in nursing homes. We call them long-term healthcare facilities in Quebec and Canada. We knew it. I had people calling me in April asking if I would represent, and I said I'm never in a million years, but I just can't do it. But and our problem here was that we had no PPE in the early days because our government donated it to China quite literally in February, knowing that this was all looming. And then when the stuff hit the fan here, they don't have face masks, they don't have visors, they don't even have enough gloves, which they got by April or May. But by that time, the damage was done. And it's like it was 78 or 80% of the fatalities were in nursing homes, but like something like a majority of even higher degree of the spread occurred from nursing homes because you had staff going from one nursing home to the other, spreading it, and they could detect the origination from nursing homes. So we knew it in Canada. We just don't have the same political landscape. It's just it's just to cover up negligence. But in the States, it's a different realm.
Yeah, I mean, it coincidentally fits, a guy who had a major influence on this public health policy, Bill Gates, has publicly said before he favored death panels. So it's kind of, interesting how the people putting out his policy proposals that in part influenced this action as a guy who favors death panels. And the guy, and this maybe be a good bridge, the guy who was talking about this at the time and said it was coming is now bringing a case up before the U.S. Supreme Court because judges are trying to use their power over litigants to suppress, censor, and punish speech.
So let's do this. We shall refer to him as AJ tonight. And I saw someone in the comment section said, nope, I knew about all of this because I was watching his channel. Not his channel, but rather his platform. Jones has filed a petition for cert. Now, I'll try to summarize it because it's tough for me catching up on something that I haven't been following from the beginning. He's being sued for defamation. It's in Connecticut.
Defamation. A bunch of cases. And I have some tangential role in that because I was his counsel for a period of time. And so, as full disclosure, so that's why I know what everything related to the case.
Well, and now my own
sued on a bunch of different theories related to statements he made or was alleged to have made concerning an event at a town in Connecticut. Another terms to stay away from because he get flags everything. But but basically what happens is he gets sent spam that has illegal material in it. As part, he never opens it. It's sent to his broadcasting platform. The part of the discovery that's issued in the case is, in my view, crazy, unprecedented, unparalleled.
So actually, just stop right there. Is the discovery, from what I understood, was in the context of an anti-SLAPP motion?
Yes. For an anti-SLAPP motion, more discovery than has ever been ordered in the history of anti-SLAPP statutes.
And this is the context where I just, coming into it, it's like, what the heck is going on? He's being sued for defamation. Connecticut has anti-SLAPP legislation, meaning if you're being sued for exercising a constitutional free speech issue, you can make a motion to dismiss on the basis that it is a strategic lawsuit against public participation. You can invoke the anti-SLAPP statutes. And then the onus goes on the plaintiff to show that they, basically to show that they have grounds to sue and that it's not a protected right. In the context of Jones' anti-SLAPP motion, they ordered discovery, and from the petition for cert, extensive discovery, it looks like. So that I understand.
Unprecedented. Basically, he ends up having to turn over everything that's ever been sent to him for years, for like 7-8 years. And so but he didn't know 90% of what's in there because it's spam stuff that no one had ever looked at. In there was illegal material that someone had tried to deliberately plant on his servers. The FBI acknowledged that he was the victim of this, but the plaintiff's lawyers use it. And because whatever you file in court, you're immune from suit on. So they get to say things in court they could not say without facing lawsuit otherwise. The media then deliberately misinterprets it and spreads one of the craziest lies about him that's ever been spread. And this is a guy who's had a lot of lies spread about him. A lot of people think they know things about him that they do not know, that they think things are true that are not true about him. There's a lot of things you can criticize him for, but 90% of what people criticize him for, he didn't do or didn't say. So this naturally agitates him. On his show, he's trying to respond to this onslaught, this massive libel against him, and voices his dislike and in some choice words about the plaintiff's lawyer in the case. All of a sudden, the court rushes in, considers dismiss. I mean, I think it was within a day or two. So much for due process, and considers dismissing and granting a judgment against him on all claims without him being able to defend himself at all. Backs off from that cliff and instead says, well, I'm just going to not allow you to do any of your anti-slap defense because I don't like what you said. And that goes up to the Connecticut Supreme Court. They take a while to rule on it. They determine it's now okay. And the problem is, here's what the new rule is. If somebody sues you, they can take away your free speech now. Because somehow just the fact that they've sued you means you no longer have First Amendment rights anymore if it relates at all to the suit, which is not. This goes right back to the 1940s, Bridges versus California. So a labor leader, and it was joined with a newspaper case. A labor leader, Harry Bridges, who would get involved in a lot of legal controversy because he was probably a communist. There's tons of stuff. He had like 3 or 4 cases go to the U.S. Supreme Court. He'd be my kind of client, always in trouble, but for the right reason. But what happened is a state court, a judge came in and said, not going to allow him to strike and do some other labor activities. He tells the secretary, somebody in FDR's cabinet, if anybody tries to enforce this judge's order, we're guaranteed to strike. Of course, the judge is enraged. What are you doing saying that you're going to challenge my order in that manner? And holds him in contempt of court and wants to send him to jail. That goes up to the U.S. Supreme Court, and the U.S. Supreme Court made clear courts are state actors like anybody else. Just because somebody's a party to your case, you have no more right to violate their First Amendment than any other state actor. And you have to have extremely emergency and extremely imminent circumstances. Great decision written by Justice Hugo Black, named after Victor Hugo, the great French writer, Les Miserables, Les Mis, and says, and the Supreme Court decision makes clear you can't do that. They also joined it to a case where the editorial page of a big newspaper was trying to put pressure on a judge to sentence certain people. And again, the court said, you cannot punish the newspaper either. That it has to be, so like even gag orders are mostly, the reason why you don't see them is they're mostly unconstitutional because they're a prior restraint.
Well, that's exactly what I was going to bring up is the Roger Stone gag order. Michael Flynn did not have a gag order. But now the question is this, from what I understood from the petition for cert, AJ did not have a gag order in effect, correct?
No, there was no prior restraint, no prior notice. He wasn't even given meaningful opportunity to be heard on this issue. And again, the people make much worse statements about lawyers every day within earshot of the courthouse, usually in the courthouse. At least a third of the time, they're saying it to me from the other side. So I've never said, "Oh my goodness, judge, put him in contempt, put him in jail." Now I've had opposing lawyers try to hold me in contempt, just for whatever excuse they want. But it's an easy misused and abused source of power, and everybody knows it's a dangerous particular tool of courts to misuse and abuse that power under their inherent authority. And they said even if the statement could be reliably and inherently determined to bring doubts on the court or even a court's order, it is not constitutional for the court to punish, to do anything to an individual simply because they're a party to the case in consequence. It's got to be in the courtroom. It's got to be, again, extreme emergency and extremely imminent criminal conduct. This didn't come close to meeting either of the two. So now the big question is, will the Supreme Court take a case with his name on it? Because the whole legal system doesn't want to apply the same rules just because they don't like him. But that's exactly who we need the First Amendment for. You don't need the First Amendment for popular speech.
Well, I was going to say, on the one hand, AJ Jones is the modern day Larry Flynt. I mean, if anybody, I think he's less. I don't know if you've seen the deposition of Larry Flynt, you might have different views of their demeanor, but the modern day equivalent.
Larry took it. That would have been a fun deposition to review in live time. Larry Flint, or Joe Francis. Oh man, there's some people. But he is politically, his politics are disliked by the establishment, and they hate him to a large degree, in my view, often for ill-justified reasons. But putting that aside, this is if we open the door to allow courts to say, as soon as somebody sues you, we're going to strip you of your First Amendment rights, even if you're a prominent broadcaster, under the pretext that, heck, you've been sued. So now you have no more any rights relating to that case in any way, shape, or form. Where you can't even, he didn't, like, those statements in Bridges were about the judges. He wasn't talking about the judges. He was talking about the opposing lawyer. You now can't criticize the opposing lawyer. I mean, without potential contempt. This is political abuse of the judicial process.
We saw what happened in the Colthage case, where when they were told, they can't make certain public statements about a pending case. This is civil and not even criminal, if that makes any difference. But is the risk not? I mean, I'm reading this and I'm just trying to appreciate from a precedential value. Is the Supreme Court not going to look at this and say this is too specific to one person? There's no broader application. There's no broader importance or meaning. So we're going to not even consider cert, because it's basically one person's problem with no broader impact.
The interest is really broad, because now it's a Connecticut Supreme Court decision that says there's a new exception to the First Amendment, and that if you're a litigant to the proceeding, courts can do whatever they want to you if the speech relates to that, regardless of the First Amendment. And that no court has ever done this before. And the only thing that got close to it was the Bridges case. And if the Supreme Court's going to continue to enforce the Bridges decision, then it has to take this case. And it's, but we'll see. But it's and again, credit to AJ for being willing to take these, because these are expensive petitions. I didn't file this petition; other lawyers did. But this is difficult, expensive work that he's been willing to do, because it defends and represents a much broader cause than him personally. He could survive this particular order. He took this up in order to defend the First Amendment writ large. He's actually like a less controversial version of Larry Flint. Well, what Larry Flint was fighting for the First Amendment, AJ is now.
The question I was going to ask, the Bridges decision, I don't know of it, no knowledge. Did it go to the Supreme Court, or was it
It was a Supreme Court decision? Justice Hugo Black wrote the decision.
So the question now is going to be, does the Supreme Court accept a petition for cert to render a decision on an issue that they've already adjudicated on, to rein in the lower court's failure to respect that precedent?
Correct. Especially because there's a bunch of courts that want to start misusing their power to suppress and censor speech. And their new pretext is, if you're a litigant in front of me, that gives me my excuse to control your speech, even if what I'm doing violates the First Amendment.
Very interesting. What do you estimate on your chances of this getting accepted for a hearing?
About 1 in, normally it would be 1 in 10. I think 1 in 3. Okay.
What's the time frame in terms of getting an answer? Is there? I don't know how that works.
It was just filed, so the other side will have a chance to respond. Then he has a chance to reply. So it'll probably be set for conference sometime this summer. Okay, interesting. Now, what's the next segue? I don't know. I'm going to our discussions. Do we? Yeah. Speaking of, there's a particular show that he's been on repeatedly, and a person he's vouched for. He's close friends with him. But I've had more building skepticism about him. But the question is there consequence for what appears to be Joe Rogan's lying about Spotify censorship? I will go with misleading or creative framing. The theory here, or this is the controversy. I didn't understand why people were pooping on Joe Rogan. I mean, people poop on him regularly, but they have a specific issue with him now. Tim Pool did a piece on this. So Joe Rogan was bought over from YouTube to Spotify. When he came over to Spotify, he brought his portfolio with him. And from what I understand, the warranties and representation, as we say in French, de part et d'autre, on both sides, was that there was no censorship. He could bring over his entire portfolio and he can freely express himself on Spotify. It turned out, I don't know if it was known or it became disclosed or they removed, but apparently some of his portfolio from YouTube was either not brought over to Spotify or removed from Spotify after having been brought over. I think from what I understand, the explanation at the time was that he left it on YouTube because they were his favorite episodes and didn't want to bring them over to Spotify. And from what I understand now,
the overall recognition is that Spotify said, we don't want these episodes on Spotify. And so effectively he was being censored, although not stating it. Effectively, Spotify was limiting his content, even though they weren't stating it. And people feel that Joe is a traitor to free speech, and they believe that Spotify lied, and maybe both lied. Did I miss something?
Yeah, that's right. So the key was Joe's brand. He got $100 million to go over and be exclusive to Spotify. And his brand was considered worth $5 to $10 billion to Spotify in stock market value. And the first concern, as soon as the deal was announced, was, is he going to be uncensored, Joe Rogan? Because his brand, his value as a unique podcaster, I mean, very few people listen to Rogan to actually listen to Rogan. They listen to the people Rogan is interviewing. And, he's got a UFC expertise. There they might listen to him. He's a comedian. He has entertainers. But what he did is he combined the AJ audience by talking about a lot of the issues that overlap with his audience, including having him on, but also the Art Bell audience. Art Bell was this old talk radio guy that people used to listen to after midnight, truck drivers, other people doing the crisscrossing the country, driving late for whatever reason. And it was like aliens and, alternative lives and, all UFOs and all that kind of stuff.
Open a slight parentheses. Wasn't there a scandal with Art Bell that he got somebody to end their lives, or there was a scandal
blamed for that, but I don't think anything ever came of it that I can recall. But I could be wrong.
Okay.
It was my nephew and other people that listened to him. I didn't listen to him much, but it was genius of Rogan. What he did is Rogan's brand was, I'm going to give you uncensored access to the secret scholars and experts that the institutional press doesn't give you access to. And because without that, Rogan's just a pedestrian podcaster. He's one of 1,000 people. What gave him that edge was the Art Bell AJ combined access to their audiences by talking about these issues. And for that, it was seen in the marketplace from day one. The only value to his brand long-term is if he is the uncensored Joe Rogan. So right away, there was concern when the deal was announced. And he put out, oh no. In fact, part of the reason he was doing this was because he was contractually protected from any kind of censorship at all. Then in September, all of a sudden they upload everything to Spotify and people are like, there's some stuff missing here. And the second excuse is the one you referenced. His first excuse was technical glitches, and he even criticized conspiracy theorists for saying otherwise. And he's been maintaining this ruse now for months. To give people an idea, before he clarified, when it came out in September that this was going to be censored Rogan, before he corrected it by saying, oh, no, it's totally just technical, don't worry. Spotify took a nearly $5 billion hit in the stock market. That's the value, the market value to the investors of whether Joe Rogan is censored or uncensored. But when he came out and said, don't worry, there's no censorship, that was worth $5 billion. If that isn't fraud on the market, I don't know what is. And now Joe last week just sort of dropped it in, in between. Oh, how he's not really censored. Oh, well, there was some stuff they didn't want me to put up. And the way he did it, people should listen to that. This is the sign of a dishonest individual. Joe loves to attack other people for grifters. It may turn out Joe Rogan is the biggest grifter in the bunch.
Who sent me the link? I saw the link, him talking about it. It was on Sargon of Akkad, so it was on Lotus Eaters Daily. I never fully appreciated it this way, and it's an amazing. Either people are going to love lawyers or hate lawyers, but the idea that Joe says, Siri says, not Siri. What am I talking about? Spotify says we're buying Joe, and the brand is uncensored. If they say we're going to buy over Joe, but he can't talk about 3 things, which he's been pretty vocal about on YouTube. Well, how many people are going to go move over to Spotify to follow their I don't want to say their hero, but to follow their brand that they subscribe to, Joe Rogan, if it's going to be Joe Rogan muzzled on Spotify, and the answer will have a market value will be much less. And so they all hide it. He moves over, he gets his 100 million, which if he says to Spotify, I have to tell them that I'm going to be censored, maybe it's only going to be worth 20 million. Yeah, I can see some people feeling a little deceived by this type of conduct. And I can see where the lack of transparency is determinate and almost, dare I say, sanctionable. Who's going to have an interest? I mean, let's just take it one step further. Someone wants to sue. Who has a legal interest to sue?
Anybody that's an investor. Now, two groups. Probably people who purchased the $9.99. You could have a class action, and that's millions of people who purchased the premium access to Spotify. So they could sue. And anybody who is an investor who would have had different value in their stock, but for the misrepresentations, the fraud of the market. It's a $5 billion lie by the measurement of the way that market responded to it initially. So at least that. The claims of the individual, there's probably 2 million people that have subscribed solely because of Rogan. But do the analysis. That's 2 million. That's 20 million a month. That's 240 million a year. I mean, these are not small claims that are potentially applicable. This was one of the biggest lies that impacted the market. But compare it. We'll only briefly talk about it. But compare it to John McAfee being criminally prosecuted for promoting various alternative cryptocurrencies. And that was far less it's still not clear to me exactly what the lie was. Everybody knew McAfee loves cryptocurrency. So it's like, and most people, the lie supposedly it was that he didn't disclose that he was going to profit from it in certain ways. But I think everybody kind of knew that. But putting that aside, that's a far less consequential lie than the one Rogan spread and spent months building out. And so people who've been listening to Rogan have also noticed a change since he's been on Spotify. There's a whole range of political topics he doesn't talk about anymore.
It's very interesting because you had actually sort of mentioned it. And now I just totally lost the train of thought. Oh, the people he has on. You had mentioned it en passant and before this was disclosed. So it's interesting to put two and two together in terms of who you were complaining or criticizing he was having on in terms of the quality of guests and who he was building rifts with. And I just want to bring this one up. MW, whatever, your name. World stage Rogan is just playing his part, making a living. There's nothing wrong with making a living. And there's nothing wrong with selling out for 100 million if you do it with transparency. I didn't ever fully appreciate, first of all, I watched Joe Rogan's clips and I don't really subscribe to anybody. I don't even have Siri, whatever it is on my car anymore. But there's nothing wrong with making a living. There's nothing wrong with, selling out if you're transparent about it. Like what would have been the harm to say, I'm going to come over, but there's certain things I can't talk about. There's certain things I'm not bringing over. What would have been the harm is he knows that it would have compromised the 100 million they were offering him. So that's where that's where you know that you're not being honest or you're not being transparent because it has an impact in all cases where people tend to be not transparent. Cuomo not releasing the numbers because he knows it's going to be used against him. Rogan potentially not disclosing the full terms of the conditions under which he's being bought out for 100 million because it would impact it. Okay,
and you can know we're being transparent because the possibility of an invite from Joe Rogan just went bye-bye.
or who knows? Maybe he'll invite one of us on to fight with us to show us how he was totally transparent. I have no. This is something. I have no aspirations of kissing butt to be anywhere or burning bridges to avoid anything. It's and my transparency. You can support us on Viva Barnes Locals. I get AdSense revenue here, and I have 300 and some odd bucks a month on Patreon, which. At one point, I'm going to shut down Patreon and Subscribe Star because it's just an added 3 clicks in a day that I don't particularly like, and you can follow us elsewhere. But no, it's just a question of transparency and just a question of being honest and disclosing what you're doing. It's and not
especially when that's part of his brand. It's not like if Trump exaggerates something, that's part of Trump's brand. He exaggerates. Mm-hmm. But Rogan's whole thing was, I'm honest, I'm open, I'm transparent, I'm uncensored. It turns out he was lying about all of it.
So it's also amazing because I just think how much of a hit would he have taken, even if he had to accept 40 million as opposed to 100 million.
My guess is it would have been a $10 million deal. He had 90 million reasons to lie.
You know what? And I maybe I'm naive in thinking that would have been enough to maintain your dignity. I don't know what good $90 million does when you can arguably risk losing everything that is intangibly valuable about you. 90 million. I mean, I guess it's FU money, but I don't even know that he needed FU money.
While promoting shallow lefties like Kyle Kalinske and Crystal Ball, and purporting to be kind of a progressive, I wonder if he understands what their tax policy proposals are. So,
well, that was someone else said he moved from California to Texas, and someone said, "Do you really want the?" Who was it that said that? I think it was on Lotus Eaters. It says, "Do you really want the Joe Rogan type?" Who helped, arguably create certain policy, now moving into the great state of Texas to bring that over there to do the same damage it did in California. Robert, I know we're gonna get people not angry. People will be disappointed if we don't talk about the Miss America. We have to talk about the Miss
yes, yeah. There's all these things I used to be able to say that I can't say, but
well, if it gets it gets demonetized. It was a lawsuit filed by whom against Miss America? It was a trans individual or trans community, a trans
a trans individual who enters pageants otherwise. And Oregon has a law like the Equality Act that they're trying to pass that's already passed the House, and so this was an interesting test for how that might work out, because the argument was public accommodation in Oregon, you can't discriminate based on gender identity. And so the argument was a pretty simple one. Miss America discriminates based on gender identity. And they admit they do so. They say that what matters is whether you're a biological woman, and that their First Amendment protects their right to advocate for that, and thus limits the ability of the Oregon statute to apply to them. And the argument of the plaintiff was the First Amendment doesn't justify this particular course of conduct. They were trying to limit what expressive association means and forced speech means. And so, yeah, the core of the claim was Miss America only allows biological women because they advocate for biological women. You read their brief, it sounds like an old school feminist brief about the reason and the need to argue for biological women in the world, to promote them, to protect them, to value them, to cherish them, to equalize the playing field, and having a man participate in that. Or biological man participate in that is against everything they preach and teach, and the whole reason why they have the pageant. And so the court ultimately said that First Amendment limits the ability of the Oregon statute to require gender identity for purposes of public accommodation, and that Miss America does not have to include people who are not biological women in its competitions going forward. But it's going to go up on appeal.
It will, and now it will. I presume this would be one that makes its way to the Supreme Court, insofar as it will. How would it work? Would it set a precedent for a law that has yet to come into effect, or would the law that comes into effect then render this precedent obsolete? So the Supreme Court might want to wait until these laws come into effect.
Because this would be interpreting whether the Oregon statute complies with the First Amendment and where it doesn't. And the same principle would apply to the Equality Act that got passed. So it would be a very important precedent. It's already an important precedent. What happens as it goes up is also going to be an important precedent.
And the interesting argument from the case was that they said it was freedom of expression of the Miss America pageant, that they have the right to the expression of their ideas being contrary to that statute. They say that it's for biological women, and to impose this on us violates our freedom of expression, and we have the right. And the court said yes for now, and we'll see where it goes.
It's a perfect example of a case, because it's Miss America probably couldn't be more culturally consequential for determining where exactly does gender identity fit into the non-discrimination laws. Particularly when it goes past employment to public accommodation.
Now, let's presume that the lower court decision gets upheld and affirmed, and all the way up to the Supreme Court. What would be the impact of that? I mean, what would be the scope of the enterprises that would be governed by that precedent versus government entities that might not be subject to that precedent?
Everybody would be. Everybody would be, because it would mean that the First Amendment protects your expressive association, and that any form of public accommodation discrimination law cannot override your First Amendment expressive associational rights. Now, you'll have to prove that that's the case in each instance, which can vary, but that would also likely protect religious institutions as well.
Would it likely protect a private establishment's designation of bathrooms?
That will be not likely. Not likely. That will still be an issue.
And would it potentially impact universities' sporting teams?
Yeah, there too. Maybe. But I mean, there's not a lot of universities that are really dedicated to advancing biological women, though. That's the whole point of Title IX. It's the reason why there's a bunch of money that goes to women's sports. Men's sports pay for women's sports in college. It's one of those under-realized phenomenon because of Title IX. There isn't as much demand to pay money for either donors or boosters or participants to observers for women's sports as there is for men's sports. Particularly men's college football pays for almost everything else. Not a lot of people want to watch rugby or whatever. Nothing against the rugby people out there in case send hate mail. So it only protects the core degrees of free speech and free religion against these kind of gender identity, cultural concepts being superimposed against their will. It doesn't necessarily solve the conundrum of how a lot of businesses handle gender identity laws, particularly when gender identity laws are going to conflict with gender protection laws, because one's biologically defined and one is subjectively defined.
Let me just pull up this question here. Dashin's rule. I like Westies, and I now like West Highland Terriers. It's a bizarre thing. I still love Bull Mastiffs. So do hospitals now have to accommodate a male who identifies as a female and put a male in the same room with a female? I guess the same question for prisons.
Yes, prisons, they already have separate procedures because they had bad procedures. They used to have, men who identify as women should not be put into prisons with other men. In my view, there's a long history of violence and abuse. They should have separate facilities, neither male nor female facilities for them. And they have a good number of protocols, not everywhere, but a lot of places have a good number of protocols, because there's a difference between not necessarily being a big fan of gender identity politics and thinking people should get beat up because of their chosen identity. People should separate the two. But there is a problem with potential with hospitals, with employers in certain contexts where the two may conflict. Sports is one of the big ones. The real big assumption is that it's not going to be very many people. And so it's going to be one, but who knows? And so and we're already seeing in some sports, biological men competing in women's sports because they now identify as women, having an advantage. That's now, and whether that's carved into the law or not is also an open question. So a lot of questions still remain unanswered, but the suit is very promising for protecting free speech and freedom of religion rights against the new woke ideology being imposed.
And just on cue, I'm bringing up David Nachson Albright says, so how about Orthodox communities that separate men from women in prayer? Mm-hmm. So presumably that'll be covered. You won't have, you would not have transgenders who insist on becoming priests. I don't know how that works in other religions, but
yeah, the big issue with the Equality Act is it attempts to overturn the religious protection laws that are on the books. And so that's why this decision was promising, because the same logic that would be applied to free speech could be applied to freedom of religion to limit the scope of these laws as it applies to at least those institutions, presumably.
All right. And I brought up another one that says real rugby is much cooler than fake UAS rugby. I played rugby in high school in the sevens. I was a great rugby player. Not so good at football.
The Aussies love it, and the Welsh love it too. But particularly in Australia, all they would talk about is rugby. No other sport mattered.
It is
now that New Zealand rugby team. That's still the greatest chant of all time. That is an intimidating chant. That is awesome. It's what my Covington kids were chanting when Nathan Phillips walked up to him. Which a lot of people don't know that context why they were misrepresented.
Yeah, let's see this. We got okay, forget we won't have time for that. I'm just looking at some comments. One more thing that we should probably get to because it's along the lines of Biden administration policies. Arguably, two-tier system. We're seeing people being released en masse, or sorry, not being released, but rather charges being dropped with prejudice for the Summer of Love riots, as opposed to the full prosecution of the law for, I'm not gonna straw man the other way, but for the Capitol Hill riots. So, first of all, what on earth is going on? I hear it and I read it. They're dropping 30 some odd or whatever charges with prejudice. Do we know the individuals? Do we know anything of the evidence, or do we just have a number and a charge?
From Andy No, who reports on this. Also, he has a locals board. He's also on locals. Is that they're major felonies for people that assaulted the courthouse, did damage to the courthouse, including people who've assaulted officers. Charges are being dropped against them en masse in Portland. Similar things happen in Seattle. Similar things are happening or look like they're about to happen in New York. Potentially those lawyers who did those Molotov cocktails to burn a police car and burn a policeman alive may get a sweetheart deal, is the rumor. And in D.C., all the people that rioted back when Trump inauguration, all of their charges were either dropped or they had basically juries refused to enforce the verdict, refused to enforce the law, jury nullification. And so that's contrasted. And in most of those cases, what Andy No has documented is that many of the people being charged had a long history of it. Allison Morrow, another good YouTube channel, also on locals, a good old school reporter. She does a great video where she goes into great detail about what it was like being a journalist covering Antifa over the many years in Seattle. So these are people with a long history of doing so, political evidence of it, a history of violence, and they're all getting to walk disproportionately. While anybody that's caught up anywhere near the Capitol Hill events of January 6th, even people who are not accused of any violent crime at all, there's mass arrests, mass surveillance, mass spying on phones. They were even spying on congressmen's phones, House members' phones, Trump administration officials' phones, even though, as Glenn Greenwald has documented, it has turned out that there was nobody armed that day, according to the testimony that came out to Congress last week. So this has got to be the weirdest insurrection in history, an insurrection that was completely unorganized, an insurrection where everybody was completely unarmed. And yet these people are getting the whole way to the government to crush them as if they were 9/11 terrorists, while the people who terrorized cities, sometimes for years, sometimes for decades in Portland and Seattle, and did it all summer, are getting to walk free without any prosecution. So it's a two-tiered system of justice on full display for the whole world, and it keeps getting worse. Eighth Amendment rights getting violated, First Amendment rights getting violated, Fourth Amendment rights getting violated. And because many of the people caught up in it, who they're targeting, almost all of them poor working class people. They're people without a lot of means, without a lot of income. They've done studies. They've shown a lot of them have suffered great financial harm over the past 10 years. People that had suffered, many of them suffered bad cycle. They're the victims of crime or other really horrendous kind of things. And so the people who cracked under pressure and decided to go into a government building, which they shouldn't have gone into, but for those that did know that they were doing it illegally, but by no means anywhere near the kind of crimes that the Summer of Love committed. And yet we're seeing a two-tier justice system in full display without any doubt. If anybody had any questions about who Chris Wray, Federalist Society member, really was as head of the FBI, they don't have any doubts now.
Yeah, I mean, it is atrocious only because we've seen what's going on. We've seen the political pressure coming from the mouths of the people on Capitol Hill about January 6th. And it's not just a relative silence. It's a diametric opposite where you have Kamala Harris at the time and celebrities raising money to bail these people out. Whereas now they want to bring down unlimited resources of the FBI and the CIA and intelligence, whoever it is, to go after, get social media pictures and go after everyone and detain them with bail conditions, which are excessive to say the least. It's on full display. The only question is who's watching. I mean, this is what I say. Right.
Only public pressure and public exposure can do anything about this, because that's the only way anybody else is going to be able to get anything done.
Yeah, it is. It's over the top. I mean, the only issue is you never know exactly what the charges are. You never know what the evidence is. So it's, again, Parkinson's law of politics. It's too complicated to understand who's being released with prejudice. It's not too difficult to understand. They broke into Capitol Hill, throw the book at them. And politics just plays into those blinders, and people ask much less questions when it's their adversary getting nailed compared to their ally getting freed.
Yep.
What else was I going to say? So that's, by the way, how I know that the notifications did not go out on this, other than a lot of people saying we're now up to like what is ordinarily the stream number, but it took an hour to get there. So I no doubt the notifications didn't go out. Oh, that was what I was going to say. By the way, we're at 3,200 thumbs up and 8,400, 8,500 watching. Hit the thumbs up. I would say, put a comment in, but that's less. Hit the thumbs up and share the stream afterwards so that people can know. I'm going to post highlights of the big sections tomorrow, but bite-sized information, easier to share and easier to digest. Knowledge is more powerful than anything, which I suspect is why notifications get delayed occasionally. Do you want to do the questions on locals?
Yeah.
I think
we have already answered some of them, but is HR 1 unconstitutional? I don't think it will pass the Senate because of the filibuster. I think both Manchin and Sinema will maintain it, though there's massive pressure on them to think otherwise. But the parts that apply to the presidential elections are likely unconstitutional, because that exclusively gives power to the state legislature. As of the House and the Senate, that's a much closer call, because there is constitutional language that gives Congress the authority to regulate certain aspects of that. So that's going to be much closer. If it were to pass, it will definitely face a bunch of lawsuits. What the courts ultimately decide as to House and Senate races is much more in doubt. Presidential races, it'd be very hard for them to say it's constitutional given how that's scaled.
What did Biden just put out by
executive? He's issuing some executive orders in lieu of HR 1 passing to immediately require a bunch of agencies to make sure people in jails and prisons know their ability to vote, things like that. So it's mostly education information. It doesn't change anything meaningfully, but it's meant to be a substitute just in case they fail to prevail on HR 1, but it will only achieve a very small portion of that.
Okay.
Someone asked whether or not wokedom can be a religion because of a Newsweek article. It would not be recognized as a religion, even if it has the tenets of it currently, nor would opposition to it be recognized as a religion, though there may be people for religious reasons who object to aspects of wokeism, such as we're identifying as an analogous case to the Miss America case that may have some protection, but that would be the scope of it.
There is. I mean, I don't think I'm going out on a limb. There's no adding to the list of recognized religions at this point. I think at this point, anyone who tries to add one risks it being regarded more as a cult than a religion. Like you can't alter the list.
I mean, people think just declaring it religion gives it to them because of Scientology. Scientology had to fight a long time with the IRS to get that designation from a tax perspective, and from a legal perspective, there's always problems with a bunch of people in black robes deciding what is and isn't a religion, but they tend to take a more restrictive approach rather than an expansive approach. So that's why that's not as easy to do. It came up in the tribal peyote case. It's had in some other cases too, but they tend to take a more limited application where they can. Whether governors can enforce the borders, they can, but the feds can always preempt them. So whatever rules the feds set preempt pretty much whatever the states do when it relates to the borders. So there's some limitations there. And the last question was whether or not Texas's law that we'll get to tonight, whether Texas's law on big tech is constitutional or whether it's also been preempted by Section 230. Open question. The legal academies or Law Twitter's official version is that without doubt, Section 230 preempts it. That's far from clear. Right now, Section 230 does preempt any law that is inconsistent with Section 230, even criminal laws, but there's legislative amendments afoot to at least change the criminal law component. Whether it preempts every law is an open question. Some of these issues have not been fully litigated the way people think it has been. They've usually only been litigated in the strict context of a defamation suit, not other areas. And whether or not it's unconstitutional depends on whether or not you see these as common carriers or not. Clearly, both Florida and Texas are looking to define big tech in certain areas as equivalent to the utilities and cable companies that they regulate. And so that'll be another question or challenge because you can restrict and restrain the speech of common carriers, or at least what they do in terms of who they allow to speak over their common carriers. So it's not as crystal clear as Law Twitter would have you believe. The law, it's going to be an uphill battle, but you might as well pass the laws because then that's even more argument to change Section 230, such that if the Supreme Court or Congress ever does change Section 230, those state laws go immediately into force. But it's an uphill battle, but not at all an impossible battle, that those laws will be recognized as outside the preemption and still constitutional.
This might be going back to HR 1. Even if, hypothetically, if it passes, and setting aside constitutional challenges, can the states not do exactly what they did on immigration issues and just say, we're not enforcing the law here? Come and get us?
I mean, it would be up in the air because it relates to a case that we'll get to next week. But there's a Voting Rights Act currently case pending in Arizona before the U.S. Supreme Court. It looks like the U.S. Supreme Court is going to say that the state's rules do not violate the Voting Rights Act. But that would give you an example where if the state rule is considered inconsistent with the federal rule, the federal courts usually enforce it. So the ability to effectively not enforce federal law will be tough in the election context.
All right. And with that said, do we have anything? Nothing else, Robert?
Yeah, that covers it for this week.
We did.
Oh, I mean, we have Dr. Seuss. Trustees probably did breach their fiduciary duty by censoring those books. The question is who would have the means of enforcing it. But trustees do have a fiduciary obligation And it's hard to see how they're acting consistent to that fiduciary obligation by censoring the publications of the person they're supposed to be publishing.
So this is I like getting something right with my creativity, and then I, get something wrong with the Swalwell lawsuit against Trump Jr., Giuliani, and DC. I was like, I'm so smart. Anti-SLAPP statute. This should get tossed. First of all, why would the state anti-SLAPP statutes not apply to a federal case in the states?
Because they're considered a substantive rule rather than a procedural rule. And for that reason, now it depends on what federal court you're in, but it's the DC federal courts that have said DC circuit says it doesn't apply. The Second Circuit has said partially doesn't apply. The Fifth and the 11th Circuit have generally said it does not apply. Ninth Circuit says it does. First Circuit says it does. So it depends on which court you're in as to where it applies and where it doesn't.
Okay. So I was going to do a video on that, but then when I realized my genius was not so genius, I passed. The Dr. Seuss, when Dr. Seuss, whoever's administering the business, whatever trustee board is doing this, when they basically come out and say, implicitly branding the author a racist and saying, or racially insensitive, saying we're going to not publish 6 of his books anymore. I was like, how on earth is that in the best interest of the estate, the legacy, and the business? People are going to say, it's, by catering to, I don't use the word wokeism, but by catering to the public tendency, they will increase sales of the other books. It's like, okay, that's a good argument, except by implicitly branding the author racially insensitive, you're not going to increase the sales of anything. And so I think they've basically tarnished the brand and the business in a manner that is sanctionable. It's not going to go anywhere, but it was a good creative thought.
Oh yeah, I mean, no doubt.
So Robert,
I don't have a published version of a Dr. Seuss book, or I would have had it behind me tonight. Instead, for those people asking, The Brethren, it's a good book by Bob Woodward, where it was one of the few times the Supreme Court talked to a reporter and leaked a lot of information about how the Supreme Court really operates. So it's, I think, back from the 70s, but it's still very good, very interesting. And the same with the Ladies and Gentlemen of the Jury. It's a great book about great opening statements and closing arguments. And we'll soon see, the Chauvin case presents a great opportunity on both sides to see great opening statements, great closing arguments, great cross-examination, all of it. We may actually, do some streams once the trial starts, nightly recapping the case, depending on what interest is and whatnot. But I think it is a great trial for people to watch, because this is a great opportunity for our court system to either give great confidence to our constitutional rules or undermine those constitutional rules. And hopefully they'll step up to the plate, not down to it.
All right. I was looking behind me to see if I had my book, Are You My Mother, on the back there for a while, but I think my kid actually took it to daycare to read. So that's my great literature behind me. Robert, that was almost close enough to a good, inspiring last word to get people into the next week. But give us another one, because we're going to end it on that.
Sure. For people who are stuff, and in fact, I have a live chat that'll be up and rolling in about 5 minutes on Viva, barneslaw.locals.com, where we can have a little after party for the events. But I think that, the Miss America case, some other things that are happening, give faith to reason why the court system can be still an effective remedy. A lot of good legislation was passed on the state level, helping reform election laws. And ordinary everyday people are getting more self-educated and self-empowered every single day to make a difference. So all of that is reason to have faith. As long as you have faith in the individual conscience of the individual person, and their cognitive capacity, that's always been the solution to problematic people and problematic problems anywhere at any time.
And for those who are not on Viva Barnes Local, Robert put up an amazing insight into Abraham Lincoln, and as bad as we think things are now, when Robert was describing the political reality at the time, I was like, oh, you know what? As we say in French, plus ça change, plus ça reste la même, or something along. The more things change, the more things stay the same. And it sounded pretty scary back then, where if we were political dissidents, I would have been scared back then. So it's good to know we have survived harder times, and will very likely survive these hard times. Everybody in the chat, thank you for the super chats. Thank you for tuning in. Thank you for the support. Wednesday is going to be Viva Barnes with Cernovich. Tuesday, I'm going live with Maxime. Yes, hold on one second. Maxime Bernier, who's the leader of the People's Party of Canada. And for anybody who's saying I only take right-wing people, I would, in a heartbeat, have Justin Trudeau on the channel, but he would not touch it with a 10-mile pole. I would have François Legault on. I don't think he's going to ever talk to me if he ever sees any of my tweets, but I'd have anybody. So anybody who's going to remain mildly respectful. So that's what's coming this week. Stay tuned for more stuff. Robert, stick around. We'll say our proper goodbyes, and everybody enjoy what's left of the weekend. Oh, and hold
Peace
on.
out.
I've lost my